You're home. It's early morning. A hard knock at the door. You look through the window. Federal agents. Badges out. ICE. Your heart stops. In the next 30 seconds, one wrong move, one word, one opened door can change everything. Not just for you, for your family. Every single day across America, people open that door without understanding what they just gave up. They think cooperation protects them. They think answering questions helps. They don't realize that the moment that door opens, a completely separate legal reality takes over, one that most people were never taught. I've spent years studying immigration enforcement law, analyzing federal court rulings, and reviewing how ICE operations actually work under the Fourth and Fifth Amendments. I've identified the exact mistakes people make in those first critical moments, and the exact words that protect you legally while keeping the situation calm. This is educational content only, not legal advice. For your specific situation, always consult a qualified immigration attorney. But what I'm about to show you is rooted entirely in U.S. constitutional law and federal court precedent. Here are the 4 critical mistakes people make when ICE comes to the door, and the exact phrases that protect you. Mistake 1. Opening the door. The mistake. There's a knock, loud, official. You hear, "Immigration, open up." Most people's instinct is immediate. They reach for the handle, they crack it open. They think refusing to open looks guilty. They think federal agents have automatic authority to enter, so they open the door. Oh, that one action just changed everything. The scenario. It's 6 a.m. You're in your apartment. Your children are still asleep. Hard knocking. A voice. ICE, open the door. You're scared. You don't want trouble. You open the door 6 inches to talk. The moment that door opens, even 6 inches, agents can claim they observed something in plain view. They can claim you implicitly consented to their presence. What felt like a cautious crack became a legal opening. Why people do it? People believe federal agents have the right to enter whenever they want. They believe that not opening the door will make things worse. They believe that cooperation will be rewarded. But here's the legal truth that most people have never been told. Legal reality. The Fourth Amendment to the United States Constitution protects every person on American soil, citizen or not, from unreasonable searches and seizures. This protection applies regardless of immigration status. The Supreme Court established in Payton v. New York, 1980, that in the absence of consent or exigent circumstances, the home is a constitutionally protected space. Federal agents, including ICE officers, generally need a judicial warrant signed by a federal judge to enter a private residence without consent. This is not a loophole. This is the Fourth Amendment. The critical distinction the court has drawn is between a judicial warrant, signed by a judge, issued under the federal rules of criminal procedure, and an administrative warrant, which is an ICE form, I-200 or I-205. Administrative warrants are issued internally by immigration officials, not by a judge. They do not authorize forced entry into a home under Stiegel v. United States, 1981, where the Supreme Court ruled that even a valid arrest warrant does not automatically authorize entry into a third party's home without a search warrant signed by a judge. Evidence problem. If you open the door voluntarily, courts interpret that as consent. Everything agents observe from that point forward becomes potentially usable. Your voluntary action eliminates the Fourth Amendment question entirely. The body cam footage shows you opening the door. That is the record, the correct move. Here is line 1. Do not open the door. Instead, speak through the closed door and say, "I do not consent to entry. Do you have a judicial warrant?" Say it clearly. Say it calmly. You're not being aggressive. You are asking a specific legal question that determines everything that follows. Why it works. This forces the agents to answer a binary legal question on the record. If they have a judicial warrant signed by a federal judge, they will say so and can pass it under the door or hold it to a window for you to read. If they have only an administrative warrant, they do not have legal authority to force entry into your home. Your refusal is lawful. Your question is lawful. And the body cam now shows you were calm, polite, and asking a constitutionally grounded question. Bottom line, Never open the door before asking whether agents possess a And if you like the video, please don't forget to leave a like, subscribe to the channel, and turn on the notifications bell. Judicial warrant. Your home is your strongest constitutional protection. Do not give it up in the first 30 seconds. Mistake 2. Answering questions. Through the door or at the threshold. The mistake. The agents say they only want to ask a few questions. You feel relieved. It's just questions. So you start talking. Where are you from? How long have you been here? What's your name? You answer because you think talking helps, because silence feels rude, because you want to show you have nothing to hide. Every answer is evidence. You just built their case for them. The scenario: ICE agents are outside. You didn't open the door. Good. But now one agent says, "We just need to verify some information. Can you tell us your name and where you were born?" You answer. You say your name. You mention your country of birth. That exchange, those two answers, can establish identity and foreign birth on a recorded body cam. Two facts that become part of an enforcement record. And you provided them voluntarily with no legal obligation to do so. Why people do it? People believe that answering basic questions is harmless. They think refusing to give their name looks suspicious. They think being polite requires responding. But under the Fifth Amendment of the United States Constitution, no person is required to be a witness against themselves. That protection applies to everyone on U.S. soil, regardless of status. Legal reality. The Supreme Court in Chavez versus Martinez, 2003, reaffirmed that Fifth Amendment protections apply during non-custodial questioning. More directly, the Board of Immigration Appeals and federal circuit courts have consistently held that statements made voluntarily to immigration officers can be used in removal proceedings. United States versus Bautista Avila in the Ninth Circuit, and related cases established that voluntary statements made without invocation of rights are admissible. There is no federal law requiring a person inside their home to answer questions from agents standing outside it, absent a judicial warrant compelling their appearance. You are not required to confirm your name, your nationality, your immigration status, or your length of time in the country. Evidence problem. Body cams record everything said at the door. Agents also take contemporaneous notes. Any statement you make, including your name if it matches a database record, can appear in a notice to appear, which initiates removal proceedings. Statements made at the door have appeared in immigration court records as voluntary admissions. The correct move. Here is line 2. I am exercising my Fifth Amendment right to remain silent. I will not answer questions without an attorney present. Say it once, clearly, through the closed door. If they continue asking, do not respond to the substance of any question. Repeat the line if necessary. Why it works. This is explicit invocation. Following Salinas versus Texas, 2013, the Supreme Court ruled that silence alone is insufficient. You must affirmatively invoke the Fifth Amendment. By saying these words out loud, you have created a legal record that your silence is not evasion. It is constitutional protection, explicitly claimed. Bottom line. Never answer questions at the door, regardless of how simple or harmless they seem. Every answer is a voluntary statement that can be used in removal proceedings. Invoke the Fifth explicitly. Say the words. Mistake 3. Signing documents without an attorney. The mistake. The agents say if you just sign this one form, they can sort everything out quickly. Or they present paperwork and say it's routine. Most people sign. They don't read it. They think signing shows cooperation and speeds things up. They just signed a voluntary departure order, or a waiver of their right to a hearing. The scenario. ICE officers are at your door, or have encountered you outside your home. One hands you a document and says, "This just confirms your information. Sign here." You want this to be over? You sign. That document may be a Form 1826, a notice of rights and request for disposition. Signing it in certain ways can constitute an agreement to voluntary departure, waiving your right to appear before an immigration judge. Or it may be a Form 1214, a warning as to rights. Signing without reading and without counsel can waive protections you didn't know you had. Why people do it? People believe that signing something routine is harmless. They think refusing to sign escalates the situation. They are afraid. But the legal reality is that certain signed immigration forms carry binding legal consequences that can eliminate the right to a hearing before an immigration judge. Legal reality. Under the Immigration and Nationality Act, specifically 8 U.S.C. Section 1229A, individuals in removal proceedings have the right to a hearing before an immigration judge. Voluntary departure under 8 U.S.C. Section 1229C can be granted under specific conditions, but certain signed waivers can affect this process. The American Immigration Council and federal immigration courts have documented cases where individuals signed documents at the point of apprehension without understanding their legal effect. The Ninth Circuit in Perez v. Mukasey and related cases has addressed how waivers signed without full understanding can affect immigration proceedings. You have the right to refuse to sign anything until you have spoken with an attorney. Evidence problem. A signed document becomes part of your immigration file. It creates a paper record that can be presented in immigration court. Unlike verbal statements that can sometimes be challenged, a signature on a federal form is a formal legal act. The correct move. Here is line 3. I do not consent to signing any documents without my attorney present. Say it clearly. Do not touch the paperwork. I do not take it from the agent's hands if possible, as physically handling documents can sometimes be interpreted as acknowledgement. Why it works. This is a lawful refusal. There is no federal requirement that a person sign immigration documents at the moment of an encounter without counsel. By stating this clearly and on camera, you preserve your right to legal review before any binding action is taken. Your attorney can review what you are being asked to sign and advise you on the consequences. Bottom line, never sign anything presented by ICE without an attorney reviewing it first. A signature is a legal act. Protect it with line 3. Mistake 4. Not having a plan or an attorney's number. Ready. The mistake. Even people who know their rights freeze in the moment. Their heart is racing, their children are in the next room. And if you like the video, please don't forget to leave a like, subscribe to the channel, and turn on the notifications bell. They can't remember what they're supposed to say. They don't have an attorney's number. They don't have any documentation of their legal status accessible. The moment overwhelms the knowledge, and so despite everything, they open the door. They answer questions. They sign the form. Not because they didn't know better, because they weren't prepared. The scenario, you've watched videos about your rights. You know the phrases. But it's 6 a.m. and there are 3 agents at your door and your hands are shaking and your mind goes blank. You say something you shouldn't. Not because you were ignorant, because preparation never became practice. Why people aren't ready? People believe they'll think clearly under pressure. They believe they'll remember what to do. But fear activates the sympathetic nervous system. Cognitive function under acute stress narrows dramatically. Without rehearsed automatic responses, even prepared people freeze. This is not weakness, it is biology. The answer is preparation before the moment arrives. Legal reality. The right to counsel in immigration proceedings is grounded in the Fifth Amendment's Due Process Clause. While the Sixth Amendment right to appointed counsel applies in criminal proceedings, immigrants in civil removal proceedings have the right to retain counsel at their own expense under 8 U.S.C. Section 1362. Organizations such as the American Immigration Lawyers Association maintain referral networks. Many jurisdictions have nonprofit immigration legal service providers. The National Immigration Law Center has published Know Your Rights materials that are consistent with federal law. Critically, if you are detained, you have the right to contact your consulate under Article 36 of the Vienna Convention on Consular Relations, to which the United States is a signatory. You must be informed of this right upon detention. If you are not informed, this becomes a potential legal challenge in your case, as established in Medellin versus Texas, 2008, and related consular notification cases. Evidence problem. Without an attorney's number memorized or written down in your home, hours or days can pass before you reach representation. During that window, you may be asked to sign documents, answer questions, or make decisions with permanent legal consequences and no counsel. The correct move. Here is line 4, and this one is not said to agents. It is said before they ever arrive. It is said to your family, to yourself, in preparation. I know my rights, I have my attorney's number, and I will not speak, sign, or open without counsel. Practically, this means write down the number of an immigration attorney or a local immigration legal aid organization and put it somewhere every adult member of your household can access immediately. Post it, know it. Also prepare a written card in English that says, "I do not consent to entry. I do not consent to searches. I am exercising my Fifth Amendment right to remain silent. I will not sign documents without an attorney. I wish to contact my attorney immediately." Hold this to the window or pass it under the door. You do not have to speak. A written invocation of rights is legally valid. Why it works. Preparation converts knowledge into action under stress. The card eliminates the need to remember phrases when your mind is flooded with fear. The attorney's number eliminates the gap between detention and representation. Together, they transform 4 phrases from information into actual protection. Bottom line, your rights only protect you if you can invoke them in the moment. Prepare before that moment comes. The 4 lines, one final time. Here is what you need. Memorize these, write them down, put them where your family can find them. Line 1. When agents knock, "I do not consent to entry. Do you have a judicial warrant?" Line 2. When agents ask questions, "I am exercising my Fifth Amendment right to remain silent. I will not answer questions without an attorney present." Line 3. When agents present documents, "I do not consent to signing any documents without my attorney present." Line 4. Before any encounter ever happens, know your attorney's number, prepare your written rights card, and make sure every adult in your home knows these lines. Stay calm, stay behind the closed door, stay polite, but stay protected. The Constitution does not ask for your status before it protects you. The Fourth Amendment says persons. The Fifth Amendment says no person. These words were written broadly because the founders understood that rights conditional on status are not rights at all. Every federal court that has examined this question has confirmed that constitutional protections apply to all persons within U.S. territory. You now know what most people don't know until it is too late. This is educational content only, not legal advice. For your specific situation, consult a qualified immigration attorney in your state. If this helped you, hit that like button. Subscribe for more constitutional breakdowns that protect real people in real situations. Share this with everyone you know because nobody should face that knock at the door without knowing exactly what to say. The people who stay protected are not the ones who comply out of fear. They are the ones who know their rights, have practiced their words, and understand that a closed door and a calm voice are not obstruction. They are the Constitution working exactly as intended.